Now, from the explanation I gave earlier, the direct answer that can be given to you, I'm taking your questions now, the direct answer that can be given to you, and I'm referring to the case of the day, our event planner or organizer and people like him, is this. Do you have contracts that you enter written with your the parties that you provide service for? In those contracts, do you make provision for a term of force majeure? And in the provision for force majeure, do you mention specific, a health situation like a pandemic or an epidemic in the nature of what has happened? If these exist, then you easily can rely on these express provisions to excuse yourself of the obligation to perform the contract, and you may not be subject to a suit to pay damages in court. I'll give a few other reasons why that will be the case. But here is one question. I'm in the same mess as the case of the day. People are calling for their money. I am a decorator in Winneba. What should I do? You didn't give us your name, but this is the circumstance. If you had a contract and there was an express term provision for force majeure, then you rely on that. You are discharged because that term in itself in the contract will say that upon the occurrence of such an event which you do not have control over, including a supernatural, intervention, which was not foreseeable, and which makes the performance of the terms of the contract impossible, impracticable, not difficult, but impossible, then that term itself in the contract says you will not be held liable. That term itself in the contract says you shall be discharged of the obligation in the contract. So you don't have to say it. The terms of the contract have already said it for you. However, we know that in this country, and most of you doing these kind of jobs don't actually enter into a formal contract with your the people you provide service for. Therefore, in this circumstance, because we are not a civil law country where we have a law, a legislation, which you can rely on to say you are excused of your obligation, what you ought to do is to sit down with the person who contracted you. You renegotiate. You sit down and mutually agree. How much have you already expended? How much of the money that was advanced is left? Listen to the plight of this person and also act in good conscience and act in good faith. If you definitely can make some refund to the person, make a refund to the person. You need to keep your business and you need a good name so that in future people can continue to come to you for business. So if they have paid 70% in advance, how much of that money have you already put into rentals or hiring different things to be done for food provision? How much has already been expended in buying certain groceries? We have another question, but we have Gabby on the line. Hello, Gabby. Gabby, welcome to COVID and the Law. Gabby can't seem to hear me. Gabby, welcome to COVID on the Law and the Law. Okay. Gabby's, screen is frozen. Gabby, do call back. And okay, hey, hi, Gabby. Hello, Gabby. Okay, it's frozen. Let me take the next question. You say you don't identify yourself. What is the difference between frustration of contract and force majeure? And that is a very important question. Whilst the two may look alike, in one, you may come to a point of being excused of your duty because of the radical change in the terms that you have bound yourself to perform. So there may be a difficulty in the performance. In force majeure, the requirement is one of an absolute circumstance of impossibility to perform, not practicable to perform. So if you followed us, for example, in the first episode, we discovered that because the e-learning teachers had been found another alternative job and they were teaching through e-learning, the terms of the contract could be said to have been amended slightly. The terms may not have been rendered completely impossible to perform. Therefore, the employer was giving work to the employee and ought to pay the employee for the work that they were doing. The terms may have been changed, or the performance of the contract may have become onerous.